before the Koforidua High Court for sentencing after being convicted for contempt. We have the details, including some reactions from the constituency, Akwatia specifically. Civil and Local Government Staff Association of Ghana, CLOGSAG, they've declared a nationwide strike beginning tomorrow due to the continuous stay in office of Samuel Adomboche as the registrar of the Births and Deaths Registry. But the government says no wrong has been done with the appointment. We'll look at the law, exactly what the law says, and more. Stay with us. Also, we stay on the matters of illegal mining as the Minister for Lands and Natural Resources, Emmanuel Amakofibua, promises to take on the fight, but gives some worrying detail of the state of illegal mining as we speak. I'll tell you the number of forest reserves that have been taken over completely by illegal miners, and then also those that are under threat as we speak. Stay with us. We have all that detail for you. As always, you're an integral part of the conversation. Let's share from you the hashtag we're using. Let's Ghana Tonight on Facebook and on X. Let's get talking. Well, let's settle for Ghana Briefs.
The minority in Parliament says it is dissatisfied with the Koforidua High Court ruling, which issues a bench warrant for arrest of the Akwatia MP, Ernest Kumi. According to Alexander Fiomakin, the treatment by the court was unfair. He, however, indicated that the caucus will ensure that Ernest Kumi abides by the law while they await a full briefing by their lawyers.
We are here to procure the court ruling and the orders of the court. The lawyers are going to brief the caucus and we will come out with our position on the matter. Meanwhile, I'm sure all necessary steps will be taken to ensure that our colleague is law-abiding and ensure that the right thing is done.
Nana Pole's tragic death remains a major talking point, with increasing calls to tackle hooliganism. Parliament addressed the issue for the first time today, with MPs unanimously urging relevant authorities to implement stricter protocols for stadium safety.
I believe these acts of hooliganism are despicable, and it is about time that we don't just pay lip service to these matters when they are raised, but also get the law enforcement agencies to also enforce the law.
If the GFA cannot follow rigorous protocols for licensing our football stadia, we should not be playing football as a country. Because football is a serious business and it's about life. And whether you like it or not, some people are going to be dissatisfied and may take the law into their hands.
Lawyers for petitioners contesting the parliamentary result in 3 constituencies in the Ashanti region are not happy with the transfer of the case from High Court 8 to High Court 2 without prior notice. The petitioners have questioned the motive, claiming it is a deliberate attempt by the respondent to unduly delay the case.
The Court 2, Court 8, I have huge respect for them, and I have no doubt of their competence and capacity. But my question here is that how would the Chief Justice transfer the cases from Court 8 to Court 2 without notice to the applicants, the petitioners in these cases? What I'm seeing now is a deliberate effort by the first respondent in these 2 cases or 3 cases to delay the matter.
The Civil and Local Government Staff Association, CLOGSAG, says it will proceed with its strike despite claims by government that their action is needless. According to CLOGSAG, it is not seeking to challenge the powers of the president in appointment, but demanding government to respect the Supreme Court's ruling not to politicize appointment at the birth and death registry. Isaac Bampuado is the executive secretary.
He was a former DC of the Mills administration. He chose to broadcast it. He said, if you wish to broadcast or otherwise manifest your political allegiance or run political office, step away from the services. This is Supreme Court talking. It's not CLOGSAG speaking or Isaac Bampuado speaking. This is the Supreme Court. Now, our members have been dismissed for flouting this law. We are not saying the president hasn't got the right to appoint. The Supreme Court is saying anybody with political color should step away from the services.
Minister for Foreign Affairs Samuel Okudzeto-Ablakwa has announced plans to review and reduce the fees charged for passport acquisition. He stated that the current fee structure is too high for the average Ghanaian, necessitating a proposal to Parliament for approval.
We are saying that passport application fees have become too expensive for ordinary Ghanaians. Ghanaians are complaining, and when we went around the country, they told us that they will want to see us do something about passport fees. So we want to take a second look at the structure. We'll go back to Parliament to amend the fees and charges. And what we want to do is to make sure that for ordinary Ghanaians, we reduce the fees, make it more affordable. I believe that there are even some categories of Ghanaians who should be able to acquire a passport free of charge. For example, students who are going on scholarship, brilliant but needy students.
It's more news on 3news.com. Make some time and visit 3news.com. This is Ghana Tonight. Coming up next, Member of Parliament for the Akwatia constituency, Ernest Kumi, in troubled waters as police pursue him to appear before the Koforidua High Court for sentencing after being convicted for contempt. We've got the details for you, including walk you through the path that this case has taken to this point. And then we'll have the lawyer for the NDC candidate also join us on this conversation. But the minority in Parliament, they're saying that they are dissatisfied with the Koforidua High Court ruling, which issued a warrant for arrest of the Akwatia Member of Parliament, Ernest Kumi. Minority Leader Alexander Apenyomarkin says the caucus will ensure that Ernest Kumi abides by the law while they await a full briefing by their lawyers on this matter. Take a look.
Here to procure the court ruling and the orders of the court. The lawyers are going to brief the caucus and we will come out with our position on the matter. Meanwhile, I'm sure all necessary steps will be taken to ensure that our colleague is law-abiding and ensure that the right thing is done. But we have to say that we are dissatisfied with the approach and we think that he has been treated unfairly. We would come out fully with our position when we receive full briefing.
That's the indication the minority gives. So come out their full position when they receive briefing from their lawyers on this. But we do know earlier today, Gary Nemakon showed up in court purporting to, as it were, represent the MP Ernest Kumi in this particular case. The judge did not allow that. We'll get details of exactly how things played out in court today. But let me just show you exactly what happened in Parliament earlier today. When the court gave this particular ruling on the contempt matter, Ernest Kumi was actually spotted in the chamber of Parliament. Take a look at this. But after some consultation with the leadership of the minority in Parliament, our cameras also captured him leaving the chamber That's after some consultation with the leadership. And that's him on the screen there, seated on his seat at the back. But we understand after some engagement, and that's what you see with him and also some members of the minority in Parliament having that engagement. Right after this engagement with the minority, and in fact the leadership of the minority in Parliament, our cameras captured him leaving the chamber. And as we speak, we do not have any clear indication of where he is, what the next move will be. But this is one that we're keeping tabs on. But this case has traveled a path to this point that the court has given this particular ruling. And Dennis Baberi-Wadam, XY, is with me in studio. We're going to walk you through the specific dates that this case began and what happened on the dawn of January 7 when this parliament was being sworn in. Dennis, what do we know?
Well, so Alfred, the Akwatia constituency is one of those constituencies that did not have it easy when they finished the election and they were supposed to do counting. I mean, when you see the visuals that we got on that particular day, it was quite chaotic in some of the places that they tried to do the counting. So what started off as a very peaceful election ended up with doubt a winner, at least for the 8th and 9th of December 2024. And that's because there were disagreements on quite a number of things. And this was an election that was closely contested by Ernest Kumi of the MPP, who is now the MP in Parliament for that constituency, despite that the seat is contested, as against the NDC's Henry Boachi Yadom. And that particular election saw the declaration of Ernest Kumi as the winner by 19,269 votes, as against the NDC's candidate, 17,206 particular votes. Now, because they were not able to do the declaration at the constituency as is required by law, you remember that some of the constituencies that were disputed or that had issues were brought to Accra for the final collation and then declaration. And that's where Ernest Kumi was declared actually the MP for the area.
I see.
Moving forward, I mean, because this election, like I earlier indicated, had a lot of issues, the NDC decided to head to court to challenge the validity of the election. And that was the beginning of what we are seeing now, officially. So they went by way of an election petition before the Confederate High Court. What they did next was to seek an injunction, just so they could restrain the MP, who was MP-elect then, from being sworn in Parliament. And of course, also injunct the Clerk of Parliament from swearing in the MP on the 6th of January 2024. We do remember that on that night when the MPs were going to be sworn in, the Clerk of Parliament made an announcement to the effect that he had in his possession some court processes which were to the effect that they were seeking to restrain Ernest Kumi from being sworn in. That's, we also are aware of what the majority leader came in by way of intervention to say that there's a precedent already in this house, that's in Parliament, and that's he, the majority leader, minority leader. Yes, and then he was minority leader.
Yes. You know,
had the instruction of Ernest Kumi to say that, yes, he is aware of the processes, but he's put himself up to be sworn in and to partake in all the parliamentary processes, and that whatever consequences are there, he will bear them.
So he was aware?
Yes.
Of the
clearly, this happened on the floor of Parliament.
This particular,
today. Yes. It's not as if it's something that was done on his blind side. It came to the attention of the House. You know, then there was no speaker. The House had to be, the new MPs had to be sworn in before. So it was the clerk who was in charge of that. So the clerk is on record to, and I mean, we have that particular video where the clerk was making the announcement very forcefully to draw the House attention to what the processes that were before the House. Let's take a look at that video briefly so we can get the proper context of what we're talking about.
Absolutely.
Of Akwatia, the clerk to Parliament was served a process on the 3rd of January 2025 with an order of interim injunction from a high court in Koforidua. This order was served through the legal office of the Parliamentary Service. The order directed the respondents, including the clerk to Parliament, indicating that they are restrained from proceeding to call, admit, register, swear in, recognize, gazette the said Ernest Kumi as the elected member for the Akwatia constituency. At the time of the receipt of the order, the Parliamentary Service had already completed the process of registration of Ernest Kumi as member-elect. Honorable members, so I have brought this matter to the attention of the House. That is my pleasant duty to do. The member may decide, may elect to participate, but in doing so, I'm drawing attention to Article 105 of the Constitution, and I will read, a person who sits or votes in Parliament knowing or having reasonable grounds for knowing that he is not entitled to do so commits an offence and shall be liable on conviction to such penalty as shall be prescribed by or under an enactment of Parliament. Having done this, I have discharged my noble duty. I will end there.
Mr. Chairman, the member so desires to proceed to be sworn in and to also participate in the election of the Speaker and bear the consequences himself.
So I'd like to have your mark in there.
Yes.
That Ernest Kumi elected to be sworn in and bear the consequences.
Yes, that was categorically stated.
I see, that's pretty clear.
Yes, so it presupposes they knew what was coming, but they were ready for it.
With this contempt?
This is where we are now. And this is the main reason for which today we are hearing that a bench warrant has been issued for his arrest because he's been convicted of contempt.
Well, let's have a conversation on this. And then it's just to also, put some understanding to this. A court ruling of contempt would have to tick a few boxes, isn't it?
Yes.
I mean, to the extent that either the person should maybe know about the contempt, that's a court of competent jurisdiction should have issued a court order. This person should know about the court order and willfully decides not to go according to the court order.
Precisely.
And all of these have been fulfilled by...
At least from what we have seen already, it did indicate that at the time that, in fact, the Clerk of Parliament brought that to the attention of everybody in the House. And from what the minority leader indicated to the clerk, it meant that they were aware of it. So from all the boxes that you have given, when you want to fit it in, everything has been ticked.
Let's have a conversation and stay with me, Dennis. Bernard Bediakon Bedu is a private legal practitioner for the lawyer for the NDC parliamentary candidate for the Akwatia constituency who took this matter to court and indeed the court putting out this ruling today. He moved the motion in court today, as a matter of fact. Counsel, good evening. Thank you for joining us.
Thanks for having me.
Now, you've got what you went to court to demand for. The court has indeed granted you that request. But take us through the specific milestones and the path that this case has traveled to this point. The attempts to get to Ernest Kumi, all of which did not come to any point of response from him.
Okay, so thank you, and good evening to your viewers. You would recall that after the elections, and the NDC candidate, Honorable Yadomboache Henry, had issues with the validity of Ernest Kumi being declared, and your partner in the studio helped you with the chronology of events. I need not over-elaborate on same. Eventually the matter got to the police training school, and then they were declared winners. I mean, the Ernest Kumi, the current contemnor. we had issues with it, but as law-abiding as we are, we filed the petition, which essentially was challenging the validity of the declaration. Now, together with the petition, we also filed a motion ex parte for interim injunction, and it is allowed in law that if you consider the urgency of the process you are filing such that it will be difficult for you to serve the parties within that period, because you understand that with applications you need 3 clear days before a response could be given and all that. And we are talking about sometime 31st December. If you are filing an application such as injunction and you think you don't have that time where you can have all parties served, the law allows you to come ex parte. And if you file ex parte and it is even granted, it is only for 10 days. After which you at will, if you want to repeat the application, you should do that on notice so that the other party would come to court and be heard as well. So we did that, and it got moved on the 2nd of January 2025. And we convinced the court that there was a matter to be heard. That is, in fact, the underlying factor in granting applications, that you convince the court that there is a serious matter that is supposed to be determined between the two of you. And the court agreed and actually granted our prayer. Now, when the prayer was granted, we then served the order together with all other processes on the contemptor, Ernest Kumi. Now, when he got the processes, he thought that it wasn't proper. The processes, as far as he's concerned, were not properly done. And so he sought to set aside, especially the interim injunction. He filed an application to set aside the interim injunction, which application was heard on the 5th of January 2025, which was a Sunday. And it was pursuant to a fiat that had been given the judge, the learned High Court judge, by the Chief Justice, a copy of which was shared to the lawyers, and I have a copy, that the judge should set on every day until the final determination of the matter, every day, including holidays and weekends. So we were in court on a Sunday, which was on the 5th, and Ernest Kumi was there himself with his lawyer, Gary Nimako, on the application to set aside the interim injunction. Now, there was this argument, and I had come to court representing the petitioner. My argument was viva voce. When you say viva voce, it was oral, because I had not filed any. Because I found a problem with, I need to explain this to you so you know what has happened. I had found a problem with the bar number of the lawyer, supposed lawyer, or purported lawyer of Ernest Kumi. I say purported and supposed because he had not filed appearance in the matter, and he needed to file because the CI talks about the rules of procedure with regards to petition, and the rules as stated in the CI that guides the election is the same rules that is used in the High Court, which is CI 47. And CI 47 order 9 says that you should file an appearance before you can even make any case, and he had not. So I had said that he had not filed an appearance, and the judge said no, but I'll still hear him with regards to the application. The application was heard, and I responded. I sought leave of court to respond viva voce orally, and the court agreed with me. So eventually, on the 6th, a day after, the judge ruled that they had not made a case that convinced him to set aside the interim injunction, and so he dismissed the application, thereby affirming the order for interim injunction because it was still in force. That morning, the ruling was around 11. So that morning, 11:12 there. From there, Ernest Kumi proceeded. That was the 6th. So the midnight, he got to Parliament. And then you've seen the videos, what happened there. So subsequently, we decided to file these processes to have him explain to court why he willfully disobeyed the court. And you have said it, that the ingredients of proving contempt basically are 3. The authorities have stated so. The cases that the Supreme Court has determined, the ex parte affoda and then all that.
True.
First, there must be an order of the court. Secondly, the order must specify for the contemnor or the whoever it is directed to know what to do and what not to do. So he should know there should be an order, and he should know about the order, and the order should be specific. That it shouldn't be ambiguous. He should know what he's supposed to do or not supposed to do. And then the final thing is, he should have done so willingly, or he did it woefully. He knew what he was doing, that he knew he shouldn't do it, but he proceeded to do it. All this TV, we were able to convince the court.
I see. But did you at any point try serving him through his WhatsApp and other social media platforms?
Yes, we did. You know, the contempt matters are quasi-criminal. So you can't serve a lawyer. You have to serve the person. That's what the rules say, that it should be served. When you look at
correct
order 50, you should come. You should come order 50 of CI 47. You should serve the respondent directly. You can't serve his lawyer. And you see, let me explain this. I haven't said this anywhere, but I think I need to bring it up before we proceed yet. There are two ways we can proceed with this, because this is a very serious matter. It is not just contempt. Because when you recall that the clerk to Parliament on the day read a certain article in the Constitution to him, Article 105.
Yes.
Which says that if you sit in Parliament knowing very well or having reasonable cause to know that you shouldn't sit in Parliament, you are liable on conviction. That is a criminal matter. That is a criminal, not just the contempt that you disobey the court. It's a criminal matter. And your conviction should be spelled out in an act of Parliament. So when you check section 183B of the Criminal Code to Act 29, it states that if you do that, you are liable for a conviction of and a sentence of not less than 30 days. So there is also that we can, espouse, we can take on. Of course, there are a few issues about double punishment and all that, but we can report the matter to the Attorney General. He takes him on a pure criminal matter, that he actually did what he's not supposed to do according to the Criminal Code. But in this case, we chose the part of 50, section 50 of CI 47, which says that if the court can commit you for contempt of the court for disobeying its orders. So in this case, that's what we did. We came under the order 50. So order 50 says that we should serve it on him. Now, service on him was practically impossible. We went to Parliament, they were on break, and we were advised that we should look for him ourselves. So we came to court with an application, ex parte application, to have him served through his WhatsApp and then other social media handles, which we did. But interestingly, well, he could have said that he didn't see it or he wasn't using the lines again. But he asked his lawyer, I won't say his lawyers, because his lawyers, I would not know the lawyers he chose to come and represent him. But lawyer Nimako came to court, filed processes that the judge should not have proceeded because he had filed a certiorari application at the Supreme Court. So he did not see why the judge could proceed to grant ex parte application to have his client served with the processes. What I take from it essentially is that his client had come to know about the processes. In fact, he had actually told the court by so doing, by that application, that he had been served. And so there was no dispute about the fact that he had seen the application. And so he actually was served through WhatsApp and his other social media handles. Once his lawyers were in court, it was clear that he had been served. But his lawyer's problem was that because they had filed a certiorari application on the petition.
I see. So by inference, you're saying that he wouldn't have filed a certiorari at the Supreme Court if he did not know about the application that you sent to him on WhatsApp?
Not exactly. Let me explain to you. He had filed the certiorari application challenging the order for interim injunction much earlier at the Supreme Court.
Okay.
Now, he was finding it difficult serving my client. Of course, at the Supreme Court, I was not doing a case there. So he needed to serve my client for him, if he prefers me to be his lawyer at the Supreme Court, to serve me or to forward the processes to me. But he is saying that matter was still pending at the Supreme Court. That's what Gary is saying. that matter was still pending at the Supreme Court. So he did not see why, while during the pendency of that matter there, because he was challenging the order. That's what he's saying. So the judge should not have granted the application, ex parte application, to have his client served the contempt processes.
I see. But was there a return date given by the judge for sentencing?
On this, the judge couldn't have, because he would not know when he would be arrested. The bench warrant is prepared. I've seen copies. It's out there. So it will be served on a few people. Parliament would be in the known, and then the security agencies would also, because you see the constitutional injunction of the fact that you cannot serve criminal summons, you cannot arrest when he's on his way in, out, sitting in Parliament. You can't do that. That should be respected. So the only thing is that the Speaker should be in the know, because the Speaker knows what any MP should be doing with regards to parliamentary duties. So the Speaker should be in the know so that he can help us get him. Otherwise, outside the precincts of Parliament, the law enforcement agencies should be out there looking for him. And so the day he will be brought to Parliament, to the High Court, is when he would receive a sentence.
I see. But then again, what could be the possible punishment? I mean, for yes, a bench warrant, as you indicated, you've seen that bench warrant now. If things play out, yes, he's going to be jailed. But then again, what other punishment? I've seen a possible fine imposed on him, or the court could just say, go and sin no more. Are these possible outcomes?
Yes, the three are all possible. That is speaking generally. The three are all possible. Jail, but let me explain. Jail, fine, and then a caution. But it depends on the attitude or the posture of the contemnor. You see, when you are accused the way contempts are, what you do is purely a matter of your attitude. What you come to court to show, purge yourself, what we call purge yourself, is what may allow the judge to exercise his discretion in your favor and give you.
But in this instance, he cannot necessarily. Well, he will not opt to purge himself, because that would mean he declining to hold himself as MP for Akwatia. Is it not?
Well, that is his choice, because you see, something interesting happened today. They had written a letter. They said the chief whip for the minority, I'm not too sure, Shaibu, is that the name? I'm not too sure.
Yes.
Had written a letter to court that the contemnor would not be able to attend court because he's attending to some parliamentary duties. First and foremost, in my opinion, you see, that is not a letter coming from Parliament. Parliament is run by the Speaker and the clerk. The caucus cannot, on the instructions of whoever the contemnor, write to the court. That is one. The other thing the judge even said was that he would only read the letter but not even consider it, because in the opinion of the court, he is not even supposed to hold himself as MP. So how can you write a letter confirming to the court, who said that he shouldn't be an MP, telling him that he's an MP and for that matter he is doing parliament? That's quite insulting, because the court said he shouldn't be, and you are telling the court that indeed he is, and he is still performing his duty, so he can't come to court. So the court said, put that letter aside. I'll proceed with my ruling. Right. So you see, it is for him now to either, like you are saying, take the advice, pledge himself that I am no more, and then come to court and say I'm no more the Akwatia MP. But you see, the another interesting thing is that the order was for 10 days. And the order expired as far back as the 12th of January. As we speak, there is no current or live order against Ernest Kumi currently.
Right.
You see, and that is why I have a problem with the processes he has filed at the Supreme Court, because it's a shurara on a moot action. But that's a different matter. We will meet him in the Supreme Court. But you see, currently, why he is being punished is because he disobeyed the court order before. That is then, not now. So currently, there is nothing against him as MP. But what he did before is what he's being punished for, because he should not have held himself as such, and he did. And the order was for 10 days, and he did that within the lifespan of the order. And so that is what he's been punished. So he cannot purge himself now. His attitude, he even filed a motion for the judge to recuse himself just for granting the ex parte application for him to be served with the processes.
I see.
Then his lawyer came in and all this. And the court dismissed that application as well. He filed a lot of things. We will meet him wherever he wants to. But
I see.
this matter...
It's not ending anytime soon. And as you have indicated, you have cited this bench warrant for his arrest. The minority says they are going to consult their lawyers, and then they will give a full detail of what their next step will be. So, Counsel, thank you for talking to us. This is one that, as you've indicated, is just starting. So we would have another date in the coming days. Appreciate you. Bernard Bediako Bedu is a lawyer for NDC's parliamentary candidate for the Akwatia constituency. He has just given us some information that is seen a bench warrant for the arrest of the Akwatia member of parliament, Ernest Kumi. So this is one that we'll keep an eye on as well. But coming up next on Ghana tonight, Civil and Local Government Staff Association, CLOGSAG, Ghana, they've declared a nationwide strike due to the continuous stay in office of Samuel Adumboche as the registrar of the Births and Deaths Registry. But the government says no wrong has been done with the appointment. Look at the law and more. First off, let's hear from the Secretary General, that's the General Secretary, I beg your pardon, of CLOGSAG, that's Dr. Isaac Bampuado, who has indicated why they've taken this position. And in fact, the decision to go on strike begins tomorrow. And this is their position. Take a look.
It says step away from these services. If you wish to broadcast, we all know that Mr. Botri is an NDC activist. He chose to broadcast it. He was a former DC of the Mills administration. He chose to broadcast it. They said, if you wish to broadcast or otherwise manifest your political allegiance or run political office, step away from the services. This is Supreme Court talking. It's not CLOGSAG speaking or Isaac Bampuado speaking. This is the Supreme Court. Now, our members have been dismissed for flouting this law. We are not saying the president hasn't got a right to appoint. The Supreme Court is saying anybody with political color should step away from the services. We are not saying it. This is a Supreme Court ruling. Unless you are not saying Supreme Court ruling are not law. We're going to get to them with this, what the Supreme Court is saying. And if they say we should throw it out, but this is what the Supreme Court is saying. So it's for the public to judge whether we should abide by what the Supreme Court is saying or we should throw it out. The strike was called by the National Executive Council, so they are the ones that can call it off.
That's Dr. Isaac Bampuado there. But earlier today, Felix Kwatiofosu, the Minister of State in charge of Government Communications, indicated they do not agree with CLOGSAG's reasoning and position on this appointment. And as a result, they're calling on them to rescind their strike decision. This is Felix Kwatiofosu earlier today.
In fact, when it comes to the appointment of a registrar, who essentially is the head of that department, Section 2 of Act 1027 makes it clear how it ought to be done. The contention of CLOGSAG is that the registrar position is a civil service position. That has to be backed by a specific provision in law. Now, if you read the relevant section of this law, Section 2, which deals with the appointment of the registrar of births and deaths, Section 2.1 says, the registry shall have a registrar of births and deaths. Section 2.2 says, the president shall, in accordance with Article 195 of the Constitution, appoint the registrar. Now, you may seek to inquire what Article 195 says. Article 195 simply gives the president power to make appointments, and in some instances allows him to delegate that power to other entities, individuals, or organizations to do. And in the specific instance of the Births and Deaths Registry, the law governing the operations of that, the law governing the operations of that entity spells out clearly who should make the appointment. It says the president, and the president has acted in accordance with.
Felix Kwachofosu there, he makes reference to the law detailing specifically what the operations of this births and deaths registry is, and then also who should be appointed as registrar for the births and deaths registry as the president has gone by. You hear Dr. Isaac Babuado also reference a Supreme Court ruling which, in their view, strengthens their position on this matter. This is the Supreme Court ruling that Dr. Isaac Babuado referenced. This is it. Let's put it on the screen right now. This is the decision, the CLOGSAG versus Attorney General. This is a case sometime in 2017. It's been referenced a number of times whenever the persons who are considered politically exposed are appointed. And it is not specific to just this administration or what we're seeing now. In fact, the predecessor of this man whose appointment is being contested, her appointment was also contested by CLOGSAG when the ex-Wild administration, that's Nana Akufo-Addo, appointed her as registrar. So CLOGSAG, this is not the first time they are doing this. They have some history to that effect. But this 2017 Supreme Court ruling, it says in summary, quote, it is therefore the view of the judges who sat on this matter that the codes of conduct of the civil service and local government service in general do not deny civil and local government servants the freedom of association, particularly the right to join political parties of their choice. They don't deny them that. Then again, it goes on. They merely seek to place a limitation on the manifestation of that right while in service. So there's a limitation on the right, this right, to join political parties of their choice while in service in order to maintain the neutrality of the civil and local government service and foster the principles of anonymity and permanence. So essentially, yes, you are not barred from joining a political party. Don't make it evident and explicit because of the neutrality and anonymity and permanence of this particular principle in terms of the civil service appointments. What they say in sum is, if you wish to broadcast or otherwise manifest your political party allegiance and or run political office, step aside or step away from the said services. So that is what the Supreme Court ruling essentially put out. But then again, you hear Felix Kwachofosu also reference a law that also strengthens the government's position that President John Mahama has done nothing wrong in appointing the current Registrar General of the Births and Deaths Registry. This is it. This is what the Constitution specifically states. That's what Felix Kwachofosu referenced. That's the Section 2 of the Registration of Births and Deaths Act 2020, Act 1027. Appointment of the Registrar of Births and Deaths. It quotes, the registry shall have a registrar of births and deaths. The president shall, in accordance with Article 195 of the Constitution, appoint the registrar. So the president has a particular constitutional provision to reference in appointing the registrar. And I'll show you what Article 195 specifically states. The president shall, in appointing a person as a registrar, have regard to the relevant academic qualification, experience, and knowledge of that person in civil service. The registrar shall hold office on the terms and conditions specified in the letter of appointment. And so essentially, what should guide the president, apart from, and you hear what CLOGSAG is talking about, they have never questioned the academic qualification and experience and knowledge of this man that we're talking about. And then also, what does Article 195 of the 1992 Constitution say? For which reason the president must, in accordance with that article, reference in appointing the registrar. This is it. This is what Article 195 says. Appointment, etc., of public officers, subject to the provisions of this Constitution. The power to appoint persons to hold or to act in an office in the public services shall vest in the president, acting in accordance with the advice of the governing council of the service concerned, giving in consultation with the Public Services Commission. So, per the argument of Felix Kwachofosu, The president took this decision to appoint this gentleman, not alone, but acting in accordance with the advice of the governing council of the service concerned and giving consultation with the Public Services Commission, essentially. And so, for that matter, Felix Kwatiofosu says the president did no wrong. CLOGSAG thinks otherwise. They are starting their strike tomorrow. That's what the letter said, the letter communicating their strike, which we have a copy of. Essentially, they say that Thursday, 20th February 2025, that's when the strike begins. We will see how things will play out, whether there'll be some engagements to have them call off their strike, that indefinite strike that they have declared. But this is Ghana Tonight. Coming up next, while we wait for the outcomes and matters arising in the coming days, we'll go into matters related to illegal mining shortly. And that is coming up next here on Ghana Tonight, because today, the Minister for Lands and Natural Resources, Emmanuel Ama-Kofi-Boa, was in Parliament, painting a disturbing picture of Ghana's fight against illegal mining. According to him, illegal miners have taken over 9 forest reserves, preventing the Forestry Commission from accessing them. Well, the minister has been talking about this in Parliament. Galamsey continues to cause severe destruction to Ghana's lands and natural resources and water bodies. I want us to take a listen to the minister in Parliament earlier today.
Honourable Speaker, it will interest you to note that out of the 288 forest reserves that I have mentioned, a whopping 44 of these forest reserves are under serious attack by illegal miners, and an estimated area of over 5,000 hectares has been devastated. And to put it puterially, about 7,000 standard football fields is what I'm talking about. That has been devastated. 7,500 football fields gone. This is mostly occurring in these specific areas. One in the Ashanti region, the Bakwai, in Kawie, in the western region, Takwa, Dabuasi, and in the western north, Bibiani, Enche, and Juaboso, especially. Mr. Speaker, the approach adopted by illegal mining gangs is quite alarming and frightening. They are heavily armed with sophisticated weapons and very violent with large numbers of excavators, making it extremely difficult for forest guards and the rapid response team to control them, since they have no sophisticated weapons to control them. Over 9 out of the 44 forest reserves, and Mr. Speaker, this is very important, over 9 out of the 44 forest reserves have been completely taken over by these illegal mining thugs with impunity. And the Forestry Commission no longer have access to these forest reserves. This situation is dead and must be condemned by all citizens of Ghana.
Emmanuel Ama-Kofi-Boa there. And this status report of the fight against illegal mining is worrying, to say the least. This is 288 total forest reserves we have in Ghana. 44 out of them have been invaded by illegal miners. And guess what? That's not all. We have 9 of them that have been totally taken over. In fact, he says that Forestry Commission officials can't even have access to these forest reserves. Galamsey operators have blocked the entrance to these these forest reserves, so they can't even be touched. And the total hectares of land destroyed by illegal mining so far, over 5,100 hectares. And let me give you an idea of this. This is about 7,500 football fields. Picture the football field that you play on or you see on television. 7,500 of them destroyed. There's a total land size destruction by illegal mining. And these are some of the forest reserves that we do know are under siege by illegal miners. The Tano Nemeri Forest, the Tano Enyia Forest Reserve, and let's show you the Tano Enyia Forest Reserve. We have a video of the destruction that has been dealt this forest reserve, portions of this forest reserve. Take a look at this. And it's not just that one. For the Etiwa Forest as well is one forest reserve that has also been under siege. One of the few rainforests that we have in the world. I spent some 3 days in the Etiwa Forest, and this is it. Just take a look at the level of destruction there. What's going on in there? Can you tell us?
Yes, so this is an illegal activity of mining that we can see from here. And basically, because in Ghana, we don't have a policy.
This was a couple of years ago in the Etiwa Forest. So this is evidence of what the minister is talking about. But Dr. Engineer Ken Ashigbe is with the Ghana Coalition Against Galamsey. It's actually one of the conveners. He'll be joining us after this quick break on Zoom for a conversation on this latest status report on illegal mining. Stay with us.
If whiskey could talk, Johnny Walker Black Label would sing. With notes that only come with 12 years in a barrel. Sweet, smooth toffee, rich fruit, and a touch of smoke. Tastes as good as it sounds.
Drink responsibly. Not for sale to persons under 18 years of age. Not recommended for pregnant women. This advert is FDA approved.
One packet of Flamingo Pain is equal to
Well, it is almost going to say to the minister, we told you so. These issues we have known forever. It is the reason why last year in August, we had asked that the state of emergency be declared. Because how is it that a state entity, the Forest Reserve, Forest Commission, who are clothed with the power to be able to police these forest reserves, are not able to go there? And we have had incidents of these thugs, take over these forest reserves. So for us, it is not surprising. And that's why some of us were upset with the Ashanti regional minister when he decided that people in the forest reserves and on water bodies were given 2 weeks to vacate there. People who are committing a crime, do you give them time to continue the perpetration of their crime? And so, well, we would say that we have known this all this while. We've been saying this thing all this while. And that's why when the minister during his vetting talked about the fact that they were going to use water guards and things to fight this, we did not think that's the way to go. Because the challenge we have, in as much as Galamsey is not only a law enforcement issue, you need to be able to enforce the laws so that the other plans that you need to put into action, you will be able to do that. Therefore, the minister will take a while to be able to arm the forestry guards. So it is important that we deploy the police, we deploy the army. For crying out loud, these illegal miners have declared war on us as a country. And so we should use our best arsenals to be able to flush them out and make sure that, we preserve our forests. And then we can then find ways in which people who have to mine would mine properly.
We're talking about 9 of these forests that have been totally taken over by illegal miners. That's according to the minister. What could have emboldened them this much?
Why? So again, you see, the reason for all of this that is happening is the fact that just after the elections, as we saw in 2016, there was a change of the guards. The criminals who said they were aligned to the MPP then in 2016, then took over for the criminals who said they were the NDC people in 2016, 2017. And again, that is what has happened in 2024 into 2025. Immediately in December, we saw that beginning to happen. So when you go into the Awin situation, for example, it is the same thing that is happening in there, where even the MP says that he knows that some of the people who are supposed to be NDC officials, who are supposed to be stopping the people, are the people in the forest reserves. And so, what has happened is that transition has happened again. And because of the time it took for the minister to be put in place, unlike the issues of corruption, where Oral started even before they came into power, unlike the issues of education, when there was a food crisis, immediately a committee was set up. Unlike the issues of energy, where the minister now was immediately put together, the president put him together and a couple of others to fix the problem. It took a while for a response to come, so far as Galamsey is concerned. Again, all we have seen the minister do is these engagements that he's doing. And then we saw the EPA boss also go out. But the issue of deterrent, which will be law enforcement, that needs to be done, has not been done. We wrote to the current president, reminding him that the things that we're asking for, the state of emergency, making sure that we take these people who are in the forest reserves, who are on the water bodies, we take them out. How is it that the NDC, when they were in opposition, were ready to take a private member's bill into parliament to revoke LI 2462? Up till today, over a month in power, we have not seen the revocation of that. So we need, beyond the talk, we need to see His Excellency the President and his ministers be able to take some action. Otherwise, that 9 is going to increase more than 9. And the destruction that would accompany that, the loss of fauna and flora, the fact that all this carbon trading things that we're talking about, irreparable damage is being caused to us. And it is important that we see action immediately to deal with the challenge that is confronting us.
Will the declaration of the state of emergency be the most immediate action you would recommend be taking to address the situation?
It is one of the things that have to be done. Again, once the minister comes to tell us that a state agency like the Forestry Commission Guards cannot go into the places where they are supposed to, superintend over. It tells you that you have an emergency. And so when you have that, the ingredients that should enable the president to be able to declare the state of emergency are all rife. So if the state of emergency was rife in August and the NDC in opposition supported it, the same way for these 9 forest reserves, the same way for the water bodies that still have Chamfan sitting on it, require that the state of emergency should be declared.
Appreciate you for this. And this is one that will keep the steam on, because we here at Media General, we're going to be visiting some of these forest reserves and then also the water bodies, the current state of the water bodies as compared to what was the situation some 6 months ago, to understand that whether there's been progress or some more destruction to the water bodies and also the forest reserves. Thank you. Dr. Engineer Ken Ashigbe is a convener for the Ghana Coalition Against Galamsey. Appreciate you for joining us here on Ghana Tonight. But before we go, there's a statement that has just been issued by the 2024 flag bearer of the NPP, former Vice President Dr. Mahmoud Bawumia, and it's about the termination of post-December 7 jobs. Since the assuming of office of President John Dramani Mahama, has pursued, quote, a series of actions targeting Ghanaians who were legitimately employed during the previous administration. It is ironic that a party which campaigned on the wings of jobs for all Ghanaians is arbitrarily dismissing the same Ghanaians, rendering them jobless, just because a different government employed them to put their talents to bear on the nation's development and earn income to cater for themselves and their families. The least a party that campaign on jobs could do under conditions of unemployment is to also innovate and create jobs rather than dismiss people. Goes on to say that if the ills of yesterday were condemned, then unfortunately, regrettably, these dismissals have been extended to directors who are public servants and not politicians. It goes on and said to look away whilst these ills persist is to abandon his responsibility to remind President Mahama and his government of the overriding duty to live by the democratic tenets envisioned in the 1992 Constitution, and says that they must advance the democracy, our democracy as a country, and in some of the cases, the only reason for dismissal was that the persons whose livelihoods have been destroyed are known to or related to politicians, as if to suggest that they cannot live independent professional lives, however qualified they are. And there are also reports of government intention to terminate the appointments of persons performing critical jobs such as security personnel, nurses, and teachers simply because they were appointed during the tenure of the previous administration. That will be most unfortunate, he concludes. But the full complement of this is on 3news.com. There'll be a conversation on this particular statement on New Day tomorrow morning. Join Joseph Akable and the team for the big issue on this particular statement and more. And then also on 3FM 92.7, Johnny Hills with the team as well there. My name is Alfred Ocansey. Have a good night.
Ghana Tonight is brought to you by Flamingo Paint. Superior durability, superior hiding, superior coverage, simply superior.